and welcome to Speech Communication 4397, Effective Meeting Management. We're on our next to the last tape of this semester. We're going to be finishing up on parliamentary procedure today and starting a general course review for those of you that are still working on those final exams that you took home the questions for. We'll start giving you a few more clues on those. Okay, but today we're going to turn to an issue of the Parliamentary Journal, which we've used before, and as those of you who are regular listeners and or students know, is the national scholarly publication that exists for students of parliamentary procedure. And this particular issue is October 1994. But an acquaintance of mine, Bernard Sussman, who is both a professional parliamentarian and a lawyer in Washington, D.C., wrote a rather, I think, interesting article that shows how in some instances parliamentary issues actually end up in court. And you can kind of think about how you would handle this if you were in a similar situation. There's a little moral to the story in each instance, and we'll take a quick look at those at the end. The first situation is called the resolution of censure. And this involved a professor at the University of Florida Law School named Joseph Little. He was permitted by the school to continue his own legal practice, and he devoted some time giving free representation to an environmental group in a lawsuit against the state government and the city of North Miami Beach, challenging the constitutionality of a state appropriation of $12 million to buy land from the city of North Miami Beach. In the lawsuit, the city was represented by the city attorney, Jennifer Hurst. Now, the city council evidently wanted to punctuate its hostility about having this lucrative deal impeded. So at a meeting of the city council, Hurst, the city attorney, drafted and the council adopted a resolution. And you remember those resolutions with the whereases and therefore be it resolved. And the bottom line of this resolution, R83-65, said, the Council of the City of North Miami hereby censures Professor Joseph W. Little for improper use of public funds to represent private parties in litigation against the state and against the interests of the City of North Miami. Now, this resolution was brought up without notifying Professor Little and without any investigation to see if the accusations were even true. And Hurst saw to it that copies were immediately sent, which is what you usually do with resolutions. You copy them and send them out to whoever needs to know. They were immediately sent to the professor's bosses at the university, at the law school, the State Board of Regents, the state auditor, and to members of the legislature. Professor Little was put to some considerable inconvenience answering politicians' questions about the accusations in the resolution, but he was eventually exonerated on all points. When this occurred, Professor Little then sued the city, various members of the city council, and Hurst. All of this over one resolution. Little's suit contended that the resolution was a bill of attainder. We need Michael here today, the other Michael, to get into all this. A violation of his First Amendment rights, a violation of his Sixth Amendment rights to a fair hearing, a deprivation of property without due process, and libelous. The Federal District Court in Miami dismissed Little's suit, but the Circuit Court of Appeals reinstated it. The Circuit Court found that, although the resolution closely resembled a bill of attainder, it lacked the imposition of a punishment and therefore was not a bill of attainder. Similarly, since this was not a criminal proceeding, Sixth Amendment rights were not involved. The Circuit Court did, however, support Little that the resolution was an attempt to infringe his First Amendment rights and that it took property, his professional reputation, and job security without due process. The Circuit Court remanded the First Amendment and due process claims to the district court where a trial could take place on those claims. Faced with the grim proposal of going to trial, the city council suddenly demonstrated some good sense, in this author's opinion. The city council, having now gotten someone else to be city attorney, adopted Resolution 8735, in which it, quote, expresses its deep regret to, then there's a section deleted, to Professor Little that its passage of the other resolution has caused him harm and embarrassment, and so they hereby rescind the previous resolution. This was sufficient when coupled with some money to settle the case. Okay, but you see what happened here? They kind of flew off half-cocked at the instigation of the city attorney and maybe a handful of others. They passed this resolution without sufficient evidence and so forth. So, the moral of this story is that a resolution of censure is a serious thing and that it can have serious consequences for both its target and its authors. Okay? So in this situation, both parties were hurt, inconvenienced. We've got that section in Robert's Rules in the back that talks about disciplinary procedures, you know, and one of the things that you can do if you're annoyed with someone is have a motion of censure. We also talked about unseating the chairperson and you know, declaring the chair vacant and electing a new person and so forth. And so there are a variety of things, and some organizations have very specific procedures in their bylaws for how disciplinary action should be taken and so forth. But in this case, they kind of went off half-cocked and got themselves inconvenienced, in trouble, and sued before it was over with. Okay, this next one I think is even more interesting. It's called the ornamental board member. And we've talked before about serving on committees and being on boards and being responsible when you take memberships on things. Okay, one Angus DePinto was a prosperous physician who had invested money with a James E. Kelly and all these people out of state, you know, an aggressive businessman. Kelly organized an insurance company called United Security Life, and a few years down the road, DePinto attended a meeting of United's board of directors where he heard some people complain about Kelly's management. This notwithstanding, DePinto accepted an invitation anyway by Kelly to become a director of United. Now, DePinto had been assured by Kelly that the position on United's board involved no serious demands on his time or his energy. Have you ever heard that before? You know, come serve on this committee, it won't be a big deal. Well, that's what they were promising him. And that he was only doing this as a favor to his old friend, excuse me, to his old friend Kelly. DePinto certainly did no real work as a United director. He never attended the board meetings. He never phoned the company's offices for information. He never even knew that United was consistently losing huge sums of money. And he ignored the shareholders who complained to him about the way United was being run. In fact, DePinto, although he hadn't attended meetings, went ahead, and this is the real dummy move, folks, he went ahead and signed minutes which falsely reported that he had attended. And now, why would somebody do that? Well, yeah, I don't think he was paid. It may be, you know, that they needed to show that a quorum was present and he was doing this for his friend Kelly. Maybe he wanted to look like he was a good board member, even if he was, yeah, I don't know. You know, but it gives one pause for thought. DePinto didn't even know that Kelly had resigned as United's president a year after DePinto joined the board. He just kept signing off on it. I mean, this guy's really out of it. And he wasn't aware of this until more than a year after the resignation. That's when Kelly came to DePinto and explained that he was going to sell his controlling interest in United to a group of unnamed investors, and he wanted DePinto to cooperate in letting the purchasers take over United's board of directors, and then he would resign his seat. Kelly evidently made similar requests to other members of the board. Okay, a few days later, things start to snap in rapid succession. The investors, who had not been identified to United's directors, organized a new corporation. And we've got the section, Robert, about how you form a new group and your articles of incorporation and all that. Okay, Kelly signed over his shares in United to this new corporation in return for $250,000 paid to Kelly personally. The new corporation announced its intention to buy all or most of the remaining shares in United in return for some cash and mostly assets, computers, file cabinets, whatever, of the new corporation. I don't know what other assets they had, it doesn't say. The board of directors of United Security Life met just long enough to accept the resignations of a majority of the board members and elect in their place the people who had just bought Kelly's shares. Then the meeting adjourned. A few minutes later, yet another meeting of the United board commenced, this time made up entirely of the new directors, the same who had bought out Kelly earlier that same day. And they met just long enough to accept the resignations of remaining old members on the board, thereby assuring that United was now entirely in the hands of the new purchasers, and then adopting resolutions which used all of United's assets to purchase shares issued by the new corporation. Do you smell a skunk here, folks? Beware. And even though the new corporation was not legally authorized yet to issue shares, here's all this finagling and maneuvering going on. Surprise, surprise, the shares of the new corporation were worthless. All of the people who had invested in United, except for Kelly, who got his $250,000, and all of the policy holders were shafted in this deal. To make up their losses, they sued everyone involved in the transactions. What other recourse as a shareholder do you have at this point? So they're suing everyone who's involved in the transactions, alleging fraud and gross negligence. Several of United's old and new directors lost their court fights. At first, a jury felt that DePinto was an innocent pawn, but the judge felt differently and opposed an award of nearly $250,000 against DePinto. A second and third trial of this case agreed with the judge. On appeal, DePinto insisted that he was unaware of any hanky-panky and that should insulate him from liability. The appeals court felt otherwise. By accepting a position on the board of directors, notwithstanding any private assurances to the contrary, Dr. DePinto had obligated himself, on behalf of all the members and shareholders of the company, to take a serious interest and to make serious efforts on behalf of United shareholders. The court held that DePinto, despite his own lack of motivation, had a very real fiduciary duty to keep informed of corporate developments, to make inquiries and reasonable investigations into corporate activities and proposals. As part of this duty, DePinto should have refused to abandon his post and should have stayed to oppose the replacement of United's money with worthless shares. In summary, DePinto's failure to participate in the board meetings, to keep himself informed on developments, to study the financial decline and the eventual sellout of the company, and generally to protect the corporation's assets, amounted in the court's opinion to gross negligence for which he would have to compensate the corporation shareholders and policyholders. This holding was undisturbed, though the doctor kept popping up in other court cases, and even after the doctor himself had followed his patients off this mortal coil, as the author passed on, his family was dealing with claims for the judgment of this debt. So, the moral of this story is that no one is ever on a board for decorative purposes, and the honor that it carries with it also brings with it very serious responsibilities. Okay. Now, fortunately for the shareholders this time, at least you had a board member here with some assets. The doctor had enough money that they could recover some degree of their claims. Or, I guess that's as well as saying it. But anyway, they had someone to sue who had money from whom they could recover. But if you have board members like some boards I'm on, you know, financially the board's not worth enough to be sued. And in that case, then the shareholders would, you know, have just lost their money. Any comment or question? Okay. If you wanted to serve on a board, but you knew you couldn't make all of the board meetings, what should you take that position? What could you do? Yeah.
Maybe if you know the prior dates that you won't be able to make, then you could inform them. Other than that, you could maybe state that you'd be unable to make, you know, a certain amount of meetings. But if you were willing, you had to serve on that board, or if you wanted to serve on that board.
Okay. Good. Yeah, Tracy.
Maybe you could get someone to come in to substitute for you while you're absent, and let the other board members know that you won't be there, that you'd send someone in.
Okay, some boards permit an alternate, or at least informally they let someone sit in, your secretary or a vice president, even if they can't vote. So that's good too. Okay, how could this doctor have stayed informed? If he'd wanted to be, even though he's a busy man, a practicing physician and so on, is there anything he could have done? Yeah, Wally.
He could have read the minutes or tried to contact some of the other board members to find out what was going on.
Yeah, read the minutes. Well, early in the semester, well, early mid-semester, early in this section of the course, we talked about the importance of minutes and how those are the legal record of the proceedings of the organization, of the meeting. And one of the reasons you take, well, let me jog your memory. Why do you take minutes?
It's kind of like a legal transaction of what occurred during the meeting. Just
okay, one, so you have a legal record, and what's the other reason? What this doctor needed.
So you can, so you know what happened.
Yeah, so that the people who are not there will have a record and can go back and read that and check on things and find out what happened. And that's one of the reasons, probably the primary reason, that you always have the approval of the minutes in the first stages of a meeting. You know, you have your opening ceremonies or whatever, if you have those. But early on in the meeting, the first real action item almost always that you do is the approval of the minutes. And that's to kind of jog everybody's memory about what went on before. And if you're not in that meeting, then you need to request copies of the minutes. Some organizations automatically mail them out if it's not a huge organization, particularly if it's a board and you're talking about mailing out 3 or 4 sets. Something like that. That's not problematic. But those minutes give you the history of what took place. Okay, yeah, go ahead.
I was just going to ask you if that was, what was his name,
DePinto?
DePinto?
Yeah.
If that was
I don't know if that's his real name.
If that was considered fraud,
on his part?
By signing the minutes when he wasn't there, and then he received money because he was a board member, but he wasn't really an active member. I mean, isn't that something that would send him to jail?
Maybe. Yeah, certainly the improper signing of the minutes would be questionable. I don't know, you know, I've never seen the bylaws or articles of incorporation for this group, so I don't know what the requirements for being a board member are. Some organizations, you know, to be a board member, you have to contribute financially at a certain level, you have to attend a certain number of the meetings. You have some clear responsibilities that make it obvious whether you're there or not. One little group that I'm on says if you miss 3 meetings, after 3 meetings you're out in a calendar year, and they normally meet monthly unless there's a special meeting. If you miss 3 meetings, you're off the roll, you know, you're dropped from membership unless the committee votes to reinstate you. But that way there's some clarity about that. Okay, there's something else he could have done here too. Doesn't have anything to do with minutes. How else could he know what was going on with this group?
Somebody already said earlier, he could ask, he could have asked somebody that was there.
Okay, yeah, that's not what I'm driving at here, though. Besides, that's true. That's one thing you could do. What could he ask for if they didn't mail it to him? What's probably the second most important report that you have in a meeting?
Teller's report.
No, well, teller's important if we're having an election. Everybody wants that one. That's an exciting report. Think about your order of business. What do you have pretty soon after the secretary's report? No, it's before new business. You have unfinished business. Before unfinished business, you have standing committees. Before,
Treasurer
yeah,
report?
the treasurer's report. Okay, yeah, it's been a long weekend. People have been working on term projects here. You channel surfers that are piled up out there in bed going, gee, why didn't they think of that? A lot of them stayed up all night last night. We're lucky they're in class today. The treasurer's report. And sometimes the treasurer's report, you know, if these are board meetings, the treasurer's report is a lot more than just a little, you know, here's the bank statement for the month, and we have $127.19 in the bank. I wrote 2 checks and made 1 deposit. You know, here's the bottom line. Often the it's more than even the treasurer's report is actually a financial report. Another group that I go to has a treasurer's report that's anywhere from 3 to 6 or 7 pages long, because it shows all the income, all the receipts for the past month, all the disbursements, you know, every check that was written, who it was written to, and what it was written for. And then that organization is fortunate enough to have money, one of the few I belong to that has money. And so there's a whole page of certificates of deposit, treasury notes, the maturity date, the interest rate, the amount of money that each of those is worth, the interest earned in the last month. You know, so there's lots of information there. That group has a little bit of stock in a portfolio, and so there's another page that records that information. Okay? And so even if you're not at the board meeting, if you are getting the minutes and if you're getting those financial reports, you should know, you know, that enables you to get a real clear picture of what's going on, because the minutes are going to show you the actions that were taken by the board, and the financial report is going to show you the financial condition of that group. And if you're in a group that's not getting a reasonable treasurer's report, you need to ask for it. You know, if all you're getting is a bottom line number on the bank account, whether this is a civic club or a social club, fraternity, whatever, you should be having an audit committee, and we've talked about this before, but the audit committee should once a year, normally, sometimes they're biannual if it's a state or regional group, but the audit committee should be checking those canceled checks against the bank statements, etc., checking to make sure all the CDs are really where you say they are. You know, because it's one thing to type up a piece of paper and say all that money's there. And probably 10 or 15 years ago, I became aware of one group that they had one signature on the accounts, and they were embezzled out of about $40,000 because their executive director kept reporting that information as being there, and it was a single authority, and no audit committee was doing anything, you know, and so everybody's approving this piece of paper that comes through that says, oh yeah, we got all this, okay, I move the approval of the treasurer's report. Well, we've said before that you shouldn't approve that report, you should receive it, and when the audit committee signs off on their statement, that's the report that you actually approve. And so the money from that group was gone for several years, and then as they worked their way down financially and needed to cash in some of those CDs, that's when this particular woman got caught, because they weren't there to be cashed in. So that was embarrassing. But that was a case where she got away with it because this was a kind of snobby little group that didn't want to be publicly embarrassed. So they never filed charges. They just, see, I should tell it on the airways. No, I wouldn't do that. Codes of ethics and all that. But it got swept, she was embarrassed and humiliated and kicked out of membership and a few things like that. But by and large, the membership just thought that she resigned. Do what?
She got 40 grand.
Yeah, she got 40 grand for her embarrassment, so there you are. Okay. Okay, let's look at another one here. This one's kind of different and not quite as long as the previous one. Okay, the title of this one is A Membership Worth Capitalist Money. 30 years ago, we were actually worried about the American Communist Party and thought that it was a powerful organization. And so this Bill Albertson, and again, I think the names are changed to protect the innocent and guilty as the case may be. Anyway, Bill Albertson is the name we're using, was a major officer of the American Communist Party and was the manager of the Communist Bookshop in New York City. He even faced prison for resisting a law requiring Communist Party members to register with the Department of Justice. Then in 1964, J. Edgar Hoover had the idea of throwing a cat among the canaries by having the FBI plant fake documents in Albertson's car, where they would surely be found by Albertson's fellow members. The forged documents appeared to be informers' notes written in Albertson's handwriting for the FBI as if he were a snitch. The documents were found as expected, and Albertson, despite his sacrifices to the party, was expelled from membership and thrown out of his job in the bookshop. As an outcast, even among outcasts, life became very unpleasant for him. But, the author writes, I suppose he was lucky that he wasn't lynched. But anyway, he died, and when he died, he was financially ruined, embittered, and so forth a few years later. Then in the mid-1970s, the tide turns here, after Hoover was dead, an old FBI document revealing this scheme was made public. Now apparently the FBI made it public in error, but once published it was latched onto, as you might expect, by Albertson's widow. She sued the FBI under the Federal Tort Claims Act for all the damage it had done her husband, including intentional infliction of emotional distress, invasion of privacy, defamation, etc. The FBI tried to hide behind the defense of national security, but failed. By then, the secrets involved were more than 25 years old. The United States Circuit Court for Washington, D.C., or for the District of Columbia, found in her favor, and the FBI was unable to interest the Supreme Court in the appeal. Rather than have even more of its dirty laundry aired in a jury trial, even though it might have won on a technicality, since the Federal Tort Claims Act does not provide for intentional torts such as these, says the author, the FBI settled the case by paying Mrs. Albertson at least, and I'm not sure why he says at least, but anyway, at least $170,000. It's the first instance of a victim of such dirty tricks being compensated. The payment was agreed on just about the time that the Communist Party membership became worthless in Moscow. Interesting, huh? Okay, so here's the moral to this story. The moral of this story is that membership can be a valuable asset no matter what the organization is. Okay, that's just a little funny one. I mean, it's not funny to the people involved, but it's an unusual one from our point of view. Okay, we've said before that what is it that's your contract with an organization? What do you need to check before you join an organization? Yeah, the bylaws. Bylaws are your contract with the organization, and this organizational membership can work both ways. Okay. the Sussman points out that he had an earlier article in the PJ, Parliamentary Journal, in which people sued in order to be reinstated in the Ku Klux Klan and the German-American Bund and some other things. So organizational membership is an interesting phenomenon, and you need to know full well what you're getting into when you become a member. You need to know what those rights and opportunities are, and there may be interesting side consequences like this. Can you think of it? We've kind of talked about this topic in other ways. What are some other potential consequences that may occur from membership that you might not expect? I mean, how important is it to pay attention to what you belong to and what that group is doing?
Well, as with any contract, if you agree to become a member, you could, there could be something in fine print or something that you didn't read that says you have to pay more money than you thought you were going to have to pay, and they could take you to court on something like that.
Okay, there may be some fine print that you're not aware of, something you're obliged to. Okay, good. What else? Yeah.
If you're going to maintain a membership in an organization, you should keep relatively up to date with their activities, because their goals may change.
Yeah.
If even though through a period of time, even if you became inactive and you still kept your memberships.
Yeah, you keep paying your dues, and then the officers change, the goals change, and particularly if this is a national group, that you don't go to regular meetings to hear what's going on. We've talked about indemnification of officers when we talked about the bylaws, and that's often a clause toward the end, so that if there's some kind of lawsuit, the organization is responsible. Now, it just depends on how things are set up, what the group is being sued for, if the whole organization has the lawsuit filed against it. But the officers are liable if there's a hazing incident and someone gets seriously injured or killed, but the whole organization may sometimes not just maybe, is from time to time liable, because you need to know what your officers are doing, and you need to know what is being done in the name of the organization. And if this organization is suddenly out killing or capturing some species of animal, and you're going to get sued for that, or it's engaging in irresponsible behavior that causes people to be injured, you could all be liable for that. Okay, good. Okay, this one's relatively short too. This one's called the trashed candidates. This case was begun and finished within 10 days. On a January 6th, the nominations were held for a union locals officers, and the Maincuff was among, the person's name, was among those nominated for business agent, and Woodley, another person, was among those nominated for president. At the same time, a screening committee was appointed to run the election. The screening committee met on January 15th and found all the nominees eligible to run, and the election was scheduled for February 1st. On January 21st, there was a mailing by the incumbent local president to the membership, which contained a letter from the union's international president denouncing both Maincuff and Woodley for having years before worked for a competing union and for having testified in various official proceedings about criminal activities within the union. The international president's letter concluded with, I see no point in permitting such men to be candidates for positions of trust in this union, and accordingly I direct that their names be stricken as ineligible candidates. With only 2 weeks before the election, Maincuff and Woodley sued to be assured of being on the ballot. The New York State Court had no trouble finding that both of the plaintiffs were qualified to run under the terms of the union's bylaws, as they had been members in good standing for the requisite number of years and had never been disciplined. The other nominations that were made at the same time were not being disturbed, so the nomination procedures were not in doubt. Quite simply, there was nothing in the laws or bylaws which enabled the union's president to bump these two people off the ballot in this way. Since there was no time nor much point for appealing within the union's own hierarchy, the court felt it was proper to make the decision itself. The court ordered the election to go on as scheduled, with Mainculf and Woodley on the ballots as originally scheduled, and enjoined the others from interfering with this election. The moral of the story. The moral is that even high-ranking officers cannot use illegal tactics to prevent dissidents from being candidates. Okay, you still have to play by the rules. No, even if you're an officer, you can't jerk around with the process like that. Now, darn, he didn't say whether they were elected or not, so we'll just have to live in suspense on that part. Okay, but some interesting stuff going on there. And you see how fast moving that was, and how those plays were coming into being and so forth. There are times too, and I think I've mentioned this before, that parliamentarians are sometimes summoned into court as expert witnesses. Now, I've never done that. I've written up some rulings that have gone on file with groups, and that's been adequate to resolve the issue. In a couple of instances, I've written up rulings, or pardon me, not rulings, opinions that were submitted to the appropriate authorities, who went, oh, that's interesting, and just ignored them anyway and went right on in violation of process. And the only way those matters could have been resolved would have been to take them to court, but they weren't important enough in the minds of the people who requested the opinion to go through the expense and the hassle of doing that. Okay. But sometimes parliamentarians are called into court and asked to testify, and often it may involve something like a ruling of, if it's not clear to the court, is this, from a parliamentary law standpoint, is this in order, would this be permissible, so forth. Okay, the last one of these that we have is called the trashed letter to the editor. This involves another little union situation. Irvin Shimon, I guess is his name, Irvin Shimon, was a member of a union for 40 years, and he appeared as a witness in a Senate hearing on corruption within the union. The union state newsletter carried an article written by the editor characterizing the hearing as anti-union, and as having been held without notification of the union, and as having been held without allowing the union to testify, and mentioning that Shimon was presently suing the union. Shimon rather correctly felt that the article attacked him personally, and he wrote a letter to the editor asking that it be printed in the newsletter, explaining the precise nature of the Senate hearing and adding that the Senate committee had indeed invited that very editor to testify, but he had refused. The editor refused to print the letter. Shimon filed a federal lawsuit under the Labor Management Reporting and Disclosure Act, which guarantees free speech and equal rights for all union members. Shimon contended that he had no feasible alternative method of responding to this attack, since meetings were sparsely attended and the union leadership would not let him have a copy of the membership list. Moreover, there was no suitable remedy provided in the union bylaws. The court noted that the newsletter was the only medium for the exchange of information among the union's members, and that it was financed entirely by members' dues. In previous years, this newsletter had been used to boost the union's leadership, including the current editor, against dissidents, so it clearly could publish controversial subjects. In this instance, the editor had already opened up the forum by attacking Shimon, and now the court held, in view of the nature of the newsletter and of Shimon's rights as a member, it was obliged to publish his side of the story? Okay, want to guess what the moral of this story is? Okay, the moral of this story is that even a high-ranking officer can't get away with muzzling a member, especially one he has abused. Okay, now, again, the point of this is, what do the bylaws say? What rights do the bylaws give to people? You know, what kind of a contract do you have going here? And what's fair play within that organization? Any comment or question? Okay. Yeah. Mm-hmm.
This may relate to the final exam also, as far as bylaws go. When an organization constructs a set of bylaws, can they pretty much say anything they want to in the bylaws? As far, I mean, so long it follows all the articles in the bylaws. And if anybody, I don't know how to word this. They can basically put anything they want to in the contract or in the bylaws, and if anybody signs it, you know, they or agrees, not signs it, but anybody who reads it agrees to become a member, then they have to abide by those bylaws. Correct?
Mm-hmm.
Okay. So it could be. I don't want to say that could say anything, but.
Okay, are you thinking of things in particular?
Not anything in particular. I was just, as far as the final exam goes, I'm just wondering what kind of things I'm going to put on there, and I'm not asking you to tell
For
me.
you channel surfers, they have to write a short set of bylaws as part of their final activities.
I'm just wondering if there's any, if bylaws can be worded in any way, provided that they follow the, I guess for our test, the articles that are present, like Article 1 is, I think, membership, and then you describe...
Well, Article 1's name.
Name, okay.
Article
So
2, object or purpose.
Object, okay, I don't have it
3,
in front of me.
membership, yeah, right. Remember, no, mom,
Ecpad.
Okay.
I guess,
And I
basically-
think the answer to your question, knowing how you're probably thinking, the answer is yes, you can put whatever stipulations for membership that you want to in there. Now, the kind of footnote on that would be you can't do anything that's in violation of the laws of the land, you know, that's criminal activity. I guess I've never seen bylaws for a gang, but there are, I'm trying to think if there are far-fetched situations. There are some groups, at least, where the unwritten code calls for criminal activity. So you have to go out and steal some stuff in order to be part of the group or whatever. But I would hope that no state incorporating an organization would accept and approve a set of bylaws like that. I would think not. So that's probably about the only stipulation, that you can't be in violation of laws of the land because those are the highest governing document that we have. Now, from a practicality standpoint, you don't want the bylaws to get so specific that the people can't meet all the criteria. And sometimes you put things over not in bylaws but in standing rules that members of the, you know, maybe if you want to have dress codes that members will dress a certain way, they'll conduct themselves in a certain way, particularly if you were getting into something like a Masonic order or fraternity or sorority with rules about special meetings. Yeah, I'm not sure what you're thinking. You want to give me more clue about what you're thinking?
Basically, what you said about them not being too specific was, you know, enlightening there, because I remember when I think you read some of the bylaws for the some parliamentary organization. They're really meticulous. I'm wondering how meticulous or how.
You never need to be as meticulous as a parliamentarian.
Okay.
They're the most meticulous people I know. They also conduct some of the worst meetings in the world, and they know it. And part of it's because we play parliamentary games. You know, raise as many points of order, attach as many motions as you can. If you were doing the building blocks, you know, just get it as complicated as you possibly can so that the presiding officer will know they've been through a real experience before they get through. Was there another comment?
Yeah, I was just gonna ask. Bylaws can they can pretty much say what you want to say, as in any contract, but whether they'll hold up in court, is that another issue? I mean, could you say, like, say bylaws for an organization that gets together and plays like rugby or something like that? I don't know if they would ever have bylaws, but and there's a little clause in there that says members can't sue the organization if they get hurt or something like that. And
I'm not sure if I've never seen that in bylaws, but I know that there are many groups from the public schools to churches that have forms that they require people to sign, and it's more like a standing rule or an addendum or something, but it's a waiver type document that says, you know, if I'm going to take all these kids on a school bus on a field trip, the parents sign off that say they don't hold the school responsible if they fall in Armand Bayou or something, you know. And I used to, as a parent, I used to sign these things and give back to the teacher and say, you know, if you kill my child, I'm going to sue you. I mean, whether I sign this piece of paper or not. But it's saying that, and I think it would probably hold up under frivolous circumstances, that if my kid slips getting on the school bus and skins a knee or breaks an ankle, I don't have any claims here. If there's gross negligence and they determine there's an inebriated bus driver that runs in front of a Mack truck or so, you know, they might not be able to prove that, but anyway, you know, if there's a gross negligence kind of situation, then, you know, all bets are off, and so forth. But there would be some situations where you might ask members to sign and agree not to sue. Michael?
I have a question about bylaws. You know how some organizations, it's still kind of common nowadays, where in their bylaws they could say that we don't want women in our organization. If that's like in their bylaws, and then like someone sues them, they want to get in, how do they handle that? I mean, if it's their bylaws, is that they don't have to?
I'm not expert on that, but there's some real specific court information. Was it Title IX, Title 14?
I mean, would that be considered against the laws of the nation?
No, it's not against the laws of the land, but it affects, and I'm thinking in terms of sororities, well, fraternities here.
Well, I was thinking like the Rotary Club used to be kind of like that. Wasn't it all male for a while or something? Like a while back, and business women finally started trying to apply. But
there are some situations where single-sex organizations are okay. And the group I'm thinking of is SAI Sigma Alpha Iota, which is a huge national professional music fraternity. I think they call themselves fraternity, even though it's women only. It's a professional group. And I remember when I was working with some groups, when the issue came up particularly on state campuses, but on university campuses, of whether non-co-ed fraternities could exist. And the court ruling at the time was you had to be co-ed to be on campus. And many of the single-sex groups went co-ed at that point. But SAI has, like, I don't know, 50, 60,000 members, maybe more. It's been several years since I've communicated with their headquarters. They hired their own lawyers, went to Washington, did appeals and so forth, and got some kind of an exemption or a rule. I don't know if exemption is even the right word here. Got a ruling, though, that permitted them to exist as a single-sex organization. Now, it might be, but I don't know if, and maybe I'll hear as a result of this conversation, that there were equivalent organizations for men. And I don't know if the equivalency argument holds or not. There's a group Phi Mu Alpha Symphonia, which is men only. And to my knowledge, men only in a music professional group. And to my knowledge, they have not admitted any women. And both groups still exist, I think, on the University of Houston campus. But so there's some parameters to that. There was a period of closure in which the courts were very conservative in that interpretation, and then they opened back up again. But as far as private organizations go, if it doesn't involve the public, if it doesn't involve public money, if it doesn't involve the government in any way, then you're over on a different turf. Yeah. So are you aware of some single-sex groups that
No,
you don't have to name them that
No,
are a lot?
I was just thinking when you were talking about, I was wondering if you really could do what you wanted to do if you had your own bylaws, if they're all in order.
Pretty much so.
I mean,
Again,
I'm not for that, but
well, but they're, you know, I mean, to my knowledge, the social, I think it may have to do with your classification with the IRS. Now that I think about it, those 501c, 1, 2, 3, 4, 5, 6, you know, the C3s are the churches, the C7s are professionals, 5 may be educational. I don't know, I'm dusty on this part. But it has to do, it's important what your IRS classification is, because that affects your exempt status on taxes and those things. And that's the leverage that the government has in getting organizations to comply with governmental regulations. You know, you may not be eligible for grants from the education department and funding. It'll affect your tax exempt status, things like that. But if this is your own private little club, and particularly if you're not incorporated, and some groups are not, they don't have enough money to be incorporated, or they just for whatever, some groups have a lot of money and they're still not incorporated. They've just never done it. So, yeah, those bylaws are pretty much yours unless somebody files a lawsuit and takes you to court and the court rules that you're in violation of some higher law within the land. They're your bylaws. And if,
you have the option to disband if you want.
you can disband and form a new group with slightly different parameters to it. And sometimes that's the best thing to do. You know, a group just gets itself into such a mess. I think when we were talking about quorums, we talked about the group that couldn't get a quorum, and I didn't know what to tell them to do except to, you know, they couldn't even vote to disorganize themselves. So I just kind of had to die a natural death on the vine because they couldn't take any actions. So I'm not sure if that was somebody who called in that I didn't know very well. And I don't know if they actually got a lawyer and went through a legal process of dissolving the group. But certainly to start over and form a new group. But that's why it's so important to think through these things on the front end so that you get them right to start with. Convene magazine, I don't know, the last one, the one before, had, no, that's not where I saw it. It was one of the opinions in the Parliamentary Journal. They'd written in asking, and I think I've mentioned before, that there's a national advisory board of, you know, a crew of some of the best parliamentarians in the country who take these difficult questions and deal with them. And someone had written in asking them whether or not it was a good idea. They had a group of that had a number of disabled persons, and it made it very difficult for them to get to meetings. And some of the chapters, as national organizations, some of the chapters had 800 members, some of the chapters only had 100 members. A quorum for all chapters was 10 members, which is 10% of 100, which is not, you know, 10% is not a bad number, but often it's a majority. But 10 people is a very low number for 800. And so they were asking the national parliamentary advisors, is this a good quorum or not? What would your response to that be? What would you think? Should they change that quorum? Maria, hold your mic down. Tell me what you...
You should, because if you only have 10 people for a group of 800, that's a very small number. You could pass anything, anytime. Be a lot of conflict in the organization.
But if you're only getting 10 or 15 people out to a chapter meeting, and I didn't really make that clear. So I guess the question I would ask you is, what should they do? If you're barely making quorum, but it's a really low quorum, and that quorum is not representative of the whole group, what kind of choices do you have?
Maybe you could take away voting privileges to the people that couldn't make it. And
Wait, say that again?
Well, people that couldn't go to the meetings all the time, maybe you could just take away their voting privileges.
You
or
can be a
something.
member, but you can't vote?
Well, you could say if you can't come to the meeting, then maybe you should
Well,
reconsider.
okay, but that's part of the problem to start with. They're disenfranchised because they can't go to the meeting. They have the right to vote. Okay, keep brainstorming here.
You could say, oh, sorry.
So go resort to mail voting, voting through the mail? I mean...
Okay,
post-
that's a good suggestion, and probably not all the time. That could get expensive. If every time you had a motion, to approve the minutes, to approve the audit committee, to do whatever. But more voting by mail could be helpful.
You could just say quorum is whoever shows up.
Well, that could get even worse. Then you might only have 3. The line about a quorum is whoever shows up for a duly called meeting, and you always want that duly called meeting in there and then specify how much notice. That works well for small boards whose bylaws say something like they'll always meet on the 3rd Monday night of each month or the 2nd Wednesday or whatever it is. So you know when you sign on when the meeting slot is, and you have that option. And it works well for annual meetings when people come in for a convention, and you need to assure that business will be transacted at that convention. But even then, most groups find that they want a minimum of 25 people or a minimum of 50 or 10%, or they want some kind of little insurance in there so that, if there's a hurricane coming ashore and the convention's in Houston and everybody's checking out at 6 a.m. on Saturday morning and they're going to skip that 10 a.m. business meeting or whatever it is, that you don't end up with 6 people showing up at 10 a.m. carrying on the business of the organization. So, any other thought about our group with the little quorum? Maria?
Conferencing through the telephone. I mean, you don't have to actually meet someplace. Couldn't you do it electronically or via the phone
Maybe
line?
now that you have email, you could really jam up the lines with 800 people all trying to meet at once. Yeah, I'm not sure how expensive phone conferencing is. Anybody know? And I don't know how many people you can get on a line at one time. But at least your committees might be able to function that way. Okay. Overall, the advisory board's opinion was, the opinions committee said that it was probably a wise organization to leave the quorum that low, that at least they were able to transact business. And you don't want to get into a situation where you can't meet your quorum, because then you have a really big problem. And you have to go to special efforts, sometimes special expenses, calling a meeting, or trying to get enough people to show up for at least one meeting that you can take the action to change the quorum and all. But then they went on to discuss some of the things that we've been talking about how to make the people feel more involved and to encourage participation by moving meetings around from one geographical location to another. So if you've got 300 people but only 10 or 15 show up for any particular meeting, like in Houston, for example, If you met out on the west side one month and then went down south and then central and then up north and east, if you moved geographically around the city, what's the implication of that? If you're still only getting 10 or 15 people out to a meeting.
Everybody's real spread.
Okay, yeah, they're right. They're spread out, but think for a minute. We've got 300 members, 10 or 15 show up for any given meeting, and we're bouncing around over a 5 geographical area spread. No, we're still working with our disabled people here who, maybe it's, and maybe it's not physically disabled, maybe elderly people that can't drive at night or just have trouble with transportation. There are lots of reasons why people don't get to meetings besides boredom and things like that. Is moving the meeting around even a good idea? Ah, that's what I'm trying to get you to think. No, it's not.
Like a membership drive for younger people.
Right, yeah, whatever their problem is. But you're still interested in whether or not you're disenfranchising the core group. And to go out and bring in more members who don't have the problem, what's the implication of that? Whether it's a transportation problem or whatever. We'll make it a transportation problem for a while.
Whether they're just not valuable people of the organization. I mean, they might feel like
You need to hold your mic down.
they just probably won't feel like they're valuable members of the organization. They've probably been paying dues for years, and it'd probably make them feel pretty bad to just kind of toss them aside.
Okay, I'm still disenfranchised, aren't I? Just because we go get more people who can go to the meeting, now we have 400 members and we have 115 at the meeting and I'm still not there. Drat. So that didn't fix too much. I mean, we got more money now, we can do more things.
You can use some money to get some shuttle buses.
That's right. That's creative problem solving. So, yeah. So, maybe with more members and more money, you can afford to send out a better newsletter and I'll be more informed about what's going on. Okay, go back to the geographical question, because you didn't answer that one.
Try and find a centralized location to meet.
Okay,
Is
is
that
that what you, I want you to think about that. Is that what you want to do? If you're you meet central and you get 10 or 15 people, no matter where you go, and we'll just pick 5 areas for fun, east, west, north, south, central. So whatever area you've got, whether you're at Hobby Airport or Intercontinental or Greenspoint Mall or downtown or far west, whatever, you're pulling different people, and that was a good question. Maria, are you getting the same people? Yeah, if you're getting the same people each month, well then you've really got a problem.
Depending upon why they can't get to the meeting, maybe try and find out why certain people can't, write a letter asking for responses why people can't get to a meeting and find out the majority of the reasons why, and maybe try and find some way that you might be able to get them there, whether it's transportation or riding with, paying for transportation or riding with somebody.
Yeah, that could get expensive.
Right.
Yeah, so you might want to try a kind of membership drive to try to encourage more people to find ways to get there. Make it so enticing that they want to save their money and take a cab or have a friend come with them and do certain things. Okay, we're still missing one little edge here, though. What's the advantage or disadvantage, whichever it might be, of having a different 10 or 15 people each time? Is this good or bad? Marie?
I'd say it's bad because the people that meet in the first meeting, let's say in the south location, have made certain decisions, are looking at certain items on their agenda or whatever. When they meet next month in the north, they don't know what the guys in the south did.
Is that true?
Well, if you don't have the same people going, how would
Okay, you
they
don't
know?
have the same people, but how did the people in the north know what the people in the south did last month?
Yeah, a newsletter, I would think.
The minutes. Oh, yeah, you came in a few minutes after we were talking about that. Okay, the minutes will tell you. Okay, and if, I don't know, some groups have a monthly newsletter. The newsletter would help inform on that. Okay, so that could be a disadvantage then, that the group on the north side is not in sync with the group on the south side. You agree or disagree? Is that good or bad?
It could, I think it could be good or bad. Good in the sense that you don't have the same 15 people deciding the direction of the group or the organization. Bad in the sense that, well, I guess I can see how it couldn't be bad also, because essentially it'd be the same as having, if you make the rounds, it'd be the same as everybody attending one meeting and having a chance to decide on the direction. I mean, the organization would probably zigzag. I'm not making.
Are you all
sense.
confused? I'm confused. So are you saying this is good or bad?
I'm saying it's good.
That it's good that you're getting input from different
Right.
people. Okay.
And I thought that
thought that was the way you were leaning here at the finish line. But
I thought the reason I thought that it might be bad though is because they might go off into different directions, which is the same thing she pointed out.
Yeah, I'm just thinking it wouldn't be efficient because you'd have to, one little motion seems like it'd have to go around the whole hub in order to, I mean, well, I guess not. I guess they would be voting on passing stuff as each, but it still seems real disjointed to me.
It could be,
is a motion passed at any one meeting? Tracy, what do you
that's
think?
what I was going to say. And if the motion was passed, or if it wasn't passed, it goes to the north. They wouldn't disagree, so then they put it on the table, and they debate it, and each section may have a different opinion about the motions that's being heard on the table. So
Now, is that how we handle motions? Do I have to bring those
No,
Lego
I mean,
blocks
well,
in
no,
here and
I mean,
throw
but
them
not
at
like
you?
motions, but I mean, you know how people just disagree. That's just normal.
Okay, but the motion's on the floor and this is the East Side meeting, okay? With the East Side meeting, there's a motion on the floor to buy the new computer. What's going to happen to that motion? What can happen to that motion? Give me a couple of basic. You could amend it. Okay, we amended it. Picked a brand name. How are we going to get rid of that motion?
Postpone indefinitely.
Well, no, maybe you want to buy the computer. Can we vote on the motion? Here we are at the East Side meeting. We've got 15 people here. Can we adopt this motion?
Yeah, I guess you could.
Sharon, right? I couldn't get your name out.
I was just going to say that as far as these motions are concerned, regardless if it's going to fail, if it's going to be passed, or if it's going to be sent to committee, still at one time or another, whether that group doesn't solve it, the next group will. So I don't feel it's going to be any kind of a disadvantage. They're still going to be informed as long as they come to the meeting. Even if they don't, there's going to be a newsletter, there's going to be a president that's going to inform the people what's going on. So one way or another, the word will still be spread. I think there's disadvantages.
You think, I missed the last word.
There's disadvantages. I agree with what he was saying earlier, that you just get a different consensus instead of the same people monopolizing the conversation the entire time. And then maybe you have people that are very stubborn and very opinionated, and they only want certain motions made a certain way. So this way you have more of a democracy.
Okay.
I think with each different group of 15 people, there's going to be so many different agendas that it's just going to be a big mess. I don't think anything would get done.
It's just hard to assume that even though they're part of the same organization, they're all going to be working towards the same thing.
Ah, you think we might all agree on the purpose in our bylaws?
I don't think so.
No? Give you a minute to think. Okay, hopefully, because we at least agree on the broad purposes, we'll agree on specific purposes and on means to those ends part of the time, not all the time. Few groups agree on everything. Got another thought here?
Well, it's just the same. As this quote-unquote contract we as Americans have with the United States. Democrats and Republicans both have their different ideas on how to get to achieve those goals. So I think what they're saying, as far as everybody seeing the organization's goals in the same way, they might all have different ways or ideas on how to achieve those goals, and by moving around, it certainly increases the possibility of a different people wanting to move in a different direction.
Okay. The opinion of the Opinions Committee was that moving it around was a good idea because at least you get more input from more people that way. Okay? Now, the implication of this with our motion was that, well, first of all, did you tell me they could or could not vote on this motion? Okay, got two people shaking their head yes, some people still thinking about it. Yeah, if this is a main motion and we have a quorum, then a majority of those people can adopt it. So that means if the quorum is 10 people, 6 people can adopt this motion, even if we have 800 people on the membership rolls, because a majority is required to adopt a main motion as long as there's a quorum present. Okay, now but there are several ways to deal with this. If the East Side groups adopts the motion and then it moves south and they don't like it, is there anything they can do about it? If you adopt a motion and you don't like it, is there anything you can do about it? Okay.
You can amend the motion previously adopted.
Okay, if you would just want to change a little bit of it, you can amend something previously adopted. If you really don't like it and want to get rid of it, what do you do?
Maybe reconsider.
Okay, if it's the current meeting, you can
sure.
reconsider.
Okay.
There's a different word, though, if it's a new meeting. Another R word. Rescind? Yeah, rescind. Rescind goes back and undoes something. Remember the resolution insulting the law professor, and they went back and rescinded that motion. Now, that was the same group. Okay, but even if, here's a resolution passed by the East Side. Maybe they endorse a political candidate. Their bylaws permit them to do that. Next month's meeting, the minutes show this group that's meeting down on the south side that this endorsement occurred. And what kind of vote do you need to rescind something? 2/3. Okay, so it'll be a little harder to go back and undo it. But if you have 2/3 of the people on the south side who don't support that candidate, then they can go back and reject that motion. They can cancel it out. Okay. Now it may come around then to the west side and they turn around and endorse a new candidate. You could have a lot of going-ons back and forth. The other thing, we're getting short on time, the other thing you could do though is table a motion, maybe take a straw poll and just have that recorded in the minutes so that the sense of the meeting is recorded in the minutes, but then you table it, let the next group take it from the table and talk about it, and you might even want to include remarks in the minutes or something, get a sense of that meeting. If the groups really care what the different people think, you could use that kind of a format to work with that. So there are some options. Sometimes people create recessed meetings and continue agenda items that way. But referring things to committees, which might or might not be comfortable in this situation. But tabling it, taking it from the table, discussing it, might give you information in the minutes. So anyway, some interesting issues to think about. Next class, we will do kind of a survey summary of the whole course and wrap it up. Thanks.